The fourth step in negligence analysis is that of remoteness. While the duty of care inquiry asks whether the victim of the damage is reasonably foreseeable, remoteness asks whether the type of damage was foreseeable. Let's jump into the cases. When dealing with remoteness, you should be really careful when citing anything before 1961, since that's when the first wagon mound case was decided at the Privy Council, which kinda overhauled the whole standard. But just for fun, I'll tell you about In Re Polimus, a 1921 case, so you can get a sense of how different things were in the olden days. Rough weather caused leakage of gasoline aboard a ship that was carrying it, which led to explosive vapors filling the ship. A stevedore accidentally dropped a plank from somewhere high up, which caused a spark when it hit the ground, which ignited the vapors and blew up the ship. The ship owners sued the ones chartering it, since the stevedores were agents of the charterers. The court held the charterers liable, though nobody really had any way of knowing that dropping a plank would explode the ship. As per the court, the presence or absence of reasonable anticipation of damage determines the legal quality of the act as negligent or innocent. If it be thus determined to be negligent, then the question whether particular damages are recoverable depends only on the answer to the question whether they are the direct consequence of the act. So, if damage flowed as a direct consequence of the negligent act, it would be counted for the purpose of damages, even if that particular kind of damages wasn't foreseeable. As I mentioned earlier, Wagon Mound 1 overturns the direct consequence standard, setting the foundation for modern remoteness doctrine. Here, oil is carelessly spilled from a ship called the Wagon Mound, who are the defendants in this case, and then they leave the docks. The welders working on a nearby ship stop working, concerned that the oil might ignite from loose sparks or slag. They ask Caltex, the guys who sold the oil to the Wagon Mound, if it is safe to keep working, and Caltex says yeah. So, the foreman orders the welders to resume work, albeit with extra safety precautions, under the impression that furnace oil floating on the open sea doesn't ignite. Despite their precautions, loose molten metal from the welding ignited the spilled furnace oil, which burned down the wharf, all its equipment, and the third-party ship being repaired. The shipyard owners sue for damage to their wharf in this case. The claims made by the owners of the nearby ship are dealt with in Wagon Mound number 2. The judge made the factual finding that the defendants did not know and could not reasonably be expected to have known that the oil was capable of being set afire when spread on water. Starting with this case, remoteness is defined as the reasonable foreseeability of the damage type inflicted, and not as directness. The old standard, in the justice's view, was deeply unjust, for it does not seem constant with current ideas of justice or morality that, for an act of negligence, however slight or venial, which results in some trivial foreseeable damage, the actor should be liable for all consequences, however unforeseeable and however grave, so long as they can be said to be direct. On these grounds, the Wagon Mound's charterers were not found liable for the fire damage, but they were still liable for direct oil damage to the slipway, since that was reasonably foreseeable. Just because one type of damage to the plaintiff is foreseeable doesn't make you liable for other types. Another early application of this principle is the 1962 case of Smith v. Leach Brain & Company Limited. When dipping things in molten metal, you stay behind the metal shield as you work the crane. Your hand might peek out a bit when controlling the levers. A guy further away calls out instructions to you. In this case, Smith peeked his face from behind the shield inadvertently, possibly to look at the guy in the doorway or look at the article being dipped. A molten fleck hits his lip. The burn wound ulcerates into a cancer and he dies. Previous experience in the gas industry made him extra likely to get cancer. So, was the cancer a separate type of damage from the burn and too unforeseeable to pass the remoteness test? The court said no. Getting burnt was foreseeable and preventable on the employer's part. They could have just installed a proper shield instead of making the employees use corrugated metal sheets. So the type of damage is not quite the same thing as the extent of the damage. The burn was foreseeable, and the cancer was thus counted as part of the burn and consequently covered by the thin skull rule. The key quote says that, "The test is not whether these defendants could reasonably have foreseen that a burn would cause cancer and that Mr. Smith would die. The question is whether these defendants could reasonably foresee the type of injury which he suffered, namely the burn." What in the particular case is the amount of damage which he suffers as a result of that burn depends on the characteristics and constitution of the victim. Now, let's zoom over to sunny New Zealand to deal with Stevenson v. Waite Tileman Limited, 1973. Here, a steeplejack is cut by cables that had rusted and frayed. He gets horribly ill and utterly debilitated. He sues his employer for letting the cable get that bad. The jury at trial finds that the cut was foreseeable, but the debilitating illness was not. However, something like the thin skull rule kicks in again. The cut causing an infection is foreseeable, and the details of infection are a question of mere extent and not a different type from minor/common infections. We should accept as part of our law the principle of liability for harmful consequences arising from a new risk created by a foreseeable kind of injury. The foreseeability inquiry in remoteness, then, is limited to initial injury. Once foreseeability of initial injury type is shown, then all the damage caused by the injury must be covered. The principle above was robustly enforced in Canada by the Ontario Court of Appeal in Kotick v. Gray, 1981, and the ruling was upheld by the SCC. Here, a depressed guy gets in a car accident, which makes it worse. He kills himself. The defendant says that the death by suicide was not foreseeable. The ONCA disagreed. They said the car accident was a reasonably foreseeable result of the defendant driver's negligent behavior, so all damage flowing from it was covered by the thin skull rule. The defendant was therefore held liable for the worsened depression and suicide. For now, we'll jump back to the UK to discuss Hughes v. Lord Advocate 1963, AC 837 HL. Government employees opened a manhole for work. They cover it with a canvas tent and lamps as a warning, and leave the ladder outside the hole. They go away for a tea break. An 8-year-old and his 10-year-old uncle find the lamps and the ladder and decide to explore the manhole. When they go in, the paraffin lamps ignite the sewer gases, which explode and badly burn the kid. They sue the government. The court found that an explosion causing burns was not foreseeable, but burns in general are. The type of damage was foreseeable, and the extent doesn't matter, so the defendants were hit with full liability. Lord Reed wrote that, "This accident was caused by a known source of danger, but caused in a way which could not have been foreseen, and in my judgment, that affords no defense." Now that you get the idea of how this stuff works, I'm gonna go make things uncertain again. Fasten your seatbelts, because this one is a bit of a stretch. In Dowdy v. Turner Manufacturing Company Limited, 1964, an asbestos cement cover was being used to cover a cauldron of boiling liquids used to treat metal parts in a machine shop. The lid slipped into the cauldron and exploded, scattering the fluid everywhere and scalding everyone it touched. It was held that burning caused by an explosion which splashes a hot liquid is not the same damage type as burning caused by a falling object that splashes hot fluids. Getting burnt as a result of the lid falling in the cauldron and splashing scalding oil on you is reasonably foreseeable. But since the lid exploding was not foreseeable, the damage was held to be too remote and the defendants were not held liable. How do they reconcile this with Hughes v. Lord Advocate? I'll let the court speak for itself. In Hughes v. Lord Advocate, the breach of duty by the defendant on which reliance was placed was his omission to guard a dangerous allurement to children, which was liable to cause them injury, inter alia, by burning. The infant plaintiff to whom the duty was owed was allured and was injured by burning, although the particular concatenation of circumstances which resulted in his burns being more serious than they would have been expected to be could not reasonably have been foreseen. They were, nevertheless, the direct consequence of the defendant's breach of duty, and the injury was of the same kind as could reasonably have been foreseen, although of unforeseen gravity. But in the present case, the defendant's duty owed to the plaintiff in relation to the only foreseeable risk, that is, of splashing, was to take responsible care to avoid knocking the cover into the liquid or allowing it to slip in such a way as to cause a splash which would injure the plaintiff. Failure to avoid knocking it into the liquid or allowing it to slip in was of itself no breach of duty to the plaintiff. So basically, the difference between lamp burns and explosion burns is a difference in degree, but the difference between explosion-based splash burns and normal splash burns is a difference in type. Have fun with that. Another case that interprets remoteness in a more defendant-friendly way is Jolly v. Sutton London Borough Council, tried in 2000 at the House of Lords. The defendants left a rotten boat sitting on a public beach. They admitted that injury by falling through a rotten plank was foreseeable, but the damage in this case occurred by crushing when the boat fell on some teenagers who jacked it up in an apparent effort to repair it. The court found that injury by falling was not the same damage type as injury by crushing, and the defendant would not be liable because the second was not reasonably foreseeable in the circumstance. Basically, the damage is too remote to be counted if it is different in kind from the foreseeable damage, and is either fully unforeseeable or at least such a remote possibility that it could be dismissed as far-fetched. Interestingly, you can also sue for psychological damage. According to Mustafa v. Culligan 2008, finding a dead fly in a water bottle from his favorite brand gave the plaintiff depression and anxiety, so he sued the bottler. The plaintiff's claim failed because this was not considered foreseeable, as per the court. He failed to show that it was foreseeable that a person of ordinary fortitude would suffer serious injury from seeing the flies in the bottle of water. Unusual or extreme reactions to events caused by negligence are imaginable but not reasonably foreseeable. The thin skull rule only kicks in at the damages stage, so things that would not psychologically harm a person of ordinary fortitude do not pose a reasonably foreseeable risk of psychological damage, and are therefore too remote to render that damage actionable. That is, of course, unless the defendant had actual knowledge of the plaintiff's special sensibilities, in which case the injury is foreseeable. Mustafa also clarifies, or arguably updates, what is meant by reasonable foreseeability in the remoteness context. It is when there is a real risk of damage of the present type occurring, i.e., one which would occur to the mind of a reasonable person in the position of the defendant and which he would not brush aside as far-fetched. The standard is not so high as to require that the harm be more likely to occur than not, but it is higher than mere possibility. Saadati v. Moorhead 2017 clarifies that you don't need a recognizable or recognized psychiatric illness to claim mental injury. Citing paragraph 9 of Mustafa, the court wrote that, while tort law protects persons from negligent interference with their mental health, there is no legally cognizable right to happiness. Claimants must, therefore, show much more: that the disturbance suffered by the claimant is serious and prolonged and rises above the ordinary annoyances, anxieties, and fears that come with living in a civil society. Let's end off with the doctrine of novus actus intervenus. Novus actus intervenus is when a third party's act happens after the plaintiff's act, and that third party act was necessary for the damage to occur, or at least worsened it. In such cases, the defendant will not be held liable for the damage resulting from the intervening act. The defendant carries the burden of showing novus actus intervenus, if they choose to make such an argument. See Armstead v. Royal & Son Alliance Insurance Company Limited, 2024. One pristinely successful invocation of novus actus intervenus is Bradford v. Canelos, 1974, SCR 409. A fire on the restaurant grill starts, and the grill's built-in extinguishers automatically put it out. Someone thinks the extinguisher hissing was a gas leak. They scream about it, and the plaintiffs are trampled in the ensuing stampede. The trampled plaintiff sues the restaurant for negligence, claiming that the flash wouldn't have occurred if they cleaned the grill right, and that no stampede would have occurred if there had not been a flash. Though the argument worked at the trial court, the defendant won at the Supreme Court. The justices recognized that he had a state-of-the-art extinguishing system, approved and even praised by the local fire department, and it worked perfectly. There would not have been any problem at all if it weren't for that one stupid patron making shit up about a gas leak. The intervening act of some guy declaring a gas leak caused the harm, so the restaurant does not have to pay. According to the dissent, the stampede was foreseeable because hissing causes panic, and the owners knew that the extinguisher hisses. One last key precedent I'd like to mention before we go is Home Office v. Dorset Yacht, 1970. The Home Office had custody of some juvenile offenders in a rehabilitation program hosted on an island. The prisoners sneak out at night, steal a yacht, and crash it. The supervising officers literally just went to bed. Nothing was ever stopping the boys from doing this. The officers knew these guys had criminal records and a history of borstal escapes. This entire sequence of events was super foreseeable. The yacht owner sues the Home Office for letting this happen, and the Home Office denies liability, claiming that the actions of the prisoners constitute novus actus intervenus. The House of Lords ruled that if the damage is caused by the very kind of thing which is likely to flow from the wrongful or careless act of the defendant, novus actus intervenus does not apply. The Home Office was found liable on those grounds. I hope all that was at least remotely comprehensible. See you next time.